You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. My guest, Dr. Dominic Ayene and Dindiok Kwemka Joseph. Of course, Professor Stephen Kwekwasari is on Zoom with us, and joining us via phone will be Dami Yeboah Godfred, who is also a Deputy Attorney General. So let's begin by going to Professor Kwekwasari. And I deliberately do that because this is Dominic's case. Even though he was not the lawyer who litigated the case in the courtroom, it was Tony Later who did. You may have heard him a bit, and his views will remain what he has been canvassing in the court. But Professor Stephen Kwekwasari can be said to be sitting outside and just have observed what has gone on so far. Yes.
I've been given the opportunity to
start.
I brought my case before.
Yeah. Okay.
But
right.
But if no, I mean you can let Prof start, okay, and then we can.
Never mind. I think we can start with you. So, the Special Prosecutor Martin Amidu was sworn into office February 2018. He was born on the 6th of September 1951. So by the date he was sworn in, he was 66 years. That's why Dominic Ayene went to court and said that Parliament had made a law. The law they had made, that's the Special Prosecutor's Office of Special Prosecutors Act. They had made that law pursuant to the constitutional provision, and by that law added to the list of civil service provided in the Constitution. Once that was the case, Martin Amidu, if you like, is holding an office of a civil service. And the Constitution says, Article 1991, that you should retire at 60. The Supreme Court disagreed with him, but they have very cogent reasons why they did so. Let's now explore. You say this is bad.
Yes.
Explain.
Okay. So thank you very much. I want to put this case in its broader context. As you rightly pointed out, Mr. Martin Amidu was sworn into office in February 2018. At the time that he was sworn into office, he was 66 years old. And in fact, before that, I had discussed with the Honorable Muntaka Mubarak, our minority chief whip, issues relating to the vetting of Mr. Martin Amidu. And it was when he gave me the CV of the nominee that I detected that there was an age, qualification issue. And I told Muntaka that this was, the Honorable Muntaka Mubarak, that this was problematic. He said, why? And I referred him to the public service chapter of the Constitution. And as you rightly pointed out, Article 199(1) makes the compulsory retirement age of persons working in the public service 60 years of age. And thereafter, if they are to be granted a post-retirement contract, that contract should be for a maximum of 5 years, 2 years at a time, and then anyhow, not more than 5 years. And when I explained that to him, he said, what do we do? I said, well, you are supposed to, to vet him. Maybe you should put that question to him. But in my case, I think that it raises a novel constitutional issue. And that as a result of the novelty of the constitutional issue, I think possibly I would, have to go to the Supreme Court to test it. Now, I also had certain, doubts about the law as a whole. In the course of deliberations at committee, I kept pointing out that you can't take the power of the Attorney General under Article 88 of the Constitution and give it to someone and say that that person is independent of the Attorney General. And I said that because of the sui generis character of the Attorney General's office, doing that will be unconstitutional.
In law, when you say sui generis, what do you mean?
No, I mean it is, you know, is the Latin expression for something that is, you know, how will I say, there is something
novel.
No, not novel as such, but you know, something that exists in and of itself.
Okay.
All right. And so I mean, I took the view that we should not, you know, be taking the Attorney General's powers of prosecution and giving them to the Special Prosecutor and making the Special Prosecutor independent of the Attorney General. So I raised a number of constitutional issues in the course of the debate. And so when this age issue came, I was very excited about the possibility of testing it in the Supreme Court.
Right.
Now, it isn't that this was, I mean, the first time that the issue of age was being tested. All right. In the case of Yovu Yivo, an Attorney General, the Supreme Court had to determine whether or not police officers who had turned 55 2 weeks upon the coming into force of the Constitution should retire under the then Police Service Act, that is Act 350, or they should retire under Article 199(1) of the Constitution.
Right.
Because they, as plaintiffs, were arguing before the Supreme Court that they have attained an enhanced age of retirement by reason of the coming into force of the Constitution. The Attorney General then, incidentally, that was Dr. Obeda Samoa, and his deputy, the Honorable Martin Amidu, were contending before the Supreme Court that the mandatory age of retirement was 55 under the Police Service Act, Act 350, and therefore the police officers should retire at 55 because that was the mandatory. This was Martin Amidu and his Attorney General arguing for the mandatory application of Section 8(2) of the transitional provision to the 1992 Constitution. And so the Supreme Court took the view that was put forward by the, the plaintiffs in that case. Now in Yevu Yivo, interestingly, Nene Amegache, JSC now, was then Samoko Jetos Jr. and they represented, the plaintiffs. But my case is distinguishable from Yevu Yivo on the basis that Yevu Yivo dealt with persons who were already working in the public services of Ghana.
Okay.
Right.
Just hold on briefly for me. No, hold on briefly for me. I will come to you. Understand that your mic has a few issues. So we'll fix it and come back. And he was on the point of referring to a 1993 case. And in that particular case, it's actually the Supreme Court, the judge, who led the decision, who brought both of them their attention to that case. None of them apparently had, paid attention to that issue. All right. So as we try to fix your microphone, let me bring in Professor Asare. Almost said Professor HKC Prempe. Professor Asare. Okay, so let's perhaps begin where you say in your article that what the court did was a misguided purposive interpretation. And in fact, they did a certain comparison and said that the Auditor General, that's one of the cases that Dominic Ayine referred to in the Apia Ofori case. The Auditor General, the NCC chairperson and their deputies, they were using them to say, whilst they are public officers, just like Martin Amidu, they are not subject to retire at 60 years because the Constitution clearly provides when they should retire. It is the Auditor General that there is another law, that's the Audit Service Act, that says he should retire at 60 years. But even though he enjoys the privileges and conditions of a Court of Appeal judge, then you have NCC boss, you have Electoral Commission boss, You have other independent constitutional bodies like Shraj boards, but they don't retire at 60 because the Constitution provides when they should retire, or there are other laws that provide when they should retire. The administrator of the Common Fund, they use that to say Dominic is wrong in saying that once you are a public officer and your office is one under public service by the Constitution, you must retire at 60. Why do you disagree with that point of view?
Samson, very well. Let me say this is a very useful debate or discussion. I'm glad you are doing it because people often forget that the judiciary is an organ of government and they must be accountable. People must know what is going on. We hold parliamentarians accountable. We hold the president accountable. But often the judiciary is invincible to most people, largely because they write, technical language, and it's good that you are using your platform to break things down so that people can understand what is going on. Before I comment on the question that you asked, let me make 3 quick observations. I was a little worried by how long this case took. It took about 2 years plus. That's not good enough, because if you are challenging whether somebody is qualified to hold an office, and it takes you 2 years to adjudicate that, well, the person may very well have completed the term of office, and then what? The problem with delaying is that it puts the judges in a difficult situation, because if they say it's unconstitutional, then they look kind of negligent for allowing somebody to occupy a position for 2 years that was not qualified to do that. And so almost it creates an unconscious bias to say that it's constitutional. I also think the third thing is that as a country, we need to do pension reform.
That point, the MP Isaac Amu took a matter to court that he was the rightful person to occupy the seat in Ayawaso, West Wuogon. His case was determined when the MP who was illegally there had already finished the term. The court,
exactly.
The court,
and there are many examples like that.
The court ruled that he was a rightful MP. So how it delays doesn't affect how they rule. Is that not the case?
Remember that one was an appellate case. It wasn't the original court. It was a high court case that was traveling up the chain.
All right.
But this is a Supreme Court case which is not subject to appeal. And I'm not saying it influenced them. I'm just saying the potential is there.
Except that by the time they had given the decision and said he's the right MP, it was almost a useless decision because he couldn't become an MP. He couldn't go there because the time was finished. Go ahead.
That's the problem. That's the problem. The third point, Samson, is let's do some pension reform, because there are too many different pension ages for different people, and it's causing a lot of confusion. And as you can see, even the Supreme Court was a little confused by it. Now, the fourth thing is I don't agree a lot with Chief Justice Akufo on her approach to legal education, but I love her jurisprudence. And I think a new superstar is born. When I read Justice Doji's opinion, it was just brilliant. Yeah. And so that's good. That's good for the country.
That's a dissenting opinion.
It's good for the country that we have somebody like her taking the place of Justice Akufo. Now, let's go to one last point, and again, that comes from Justice Doji. She again emphasized that the parliament should stop excluding people who owe allegiance to countries other than Ghana. Yeah. Just because something is in the constitution doesn't mean parliament can do it. Because constitution is drafted by framers and all of us vote on it in a referendum. Parliament is just a class of transient legislators, and they cannot do what the constitution itself has done or undo what the constitution has done. Now, on this particular case, let me say that the reason I was shocked was that the law that the Supreme Court was interpreting is what we lawyers will call a bright line rule. It is like the Constitution saying to be a president, you have to be 40 years. And then Parliament makes a law which says, well, but if you are big enough, then you can run for president if you are 35. And then it goes to Supreme Court, and the Supreme Court says yes, because the Constitution itself gave an age, and so Parliament too can give an age. That is just so wrong. When I look at the opinion issued by the majority, I found 10 mistakes, and that's being charitable. There were more than 10 mistakes. 10 mistakes, that's being charitable. You stated the holding, but the important thing is not about the holding or who won or who lost. This is not about Dominic. It's not about Martin Amidu. It's not about the Attorney General. It's not about the President. It's about the Constitution. It's about constitutional principles. It's about stare decisis. It's about the corpus juris. It's about the body of law that we are creating to teach in the law schools. What was the reasoning behind their holding? I'll go through 10 of them, and you will see that they are funny. They are very funny. Number one, the court says, well, Article 199.1 is not a clear prohibition, inference, or language. There's nothing, it's not so clear that it bars Parliament. And later on, I'll read Article 199 for you to see whether it's clear or it's not clear. Number two, Parliament has the flexibility and authority in appropriate cases to prescribe a different retirement age as the exigencies of the job requires. Think about that. The Constitution has said something, and you are saying, no, Parliament can do something else. Number three, if the Constitution has different retirement ages, then Parliament too can give its own age. That is a misunderstanding of the difference between Constitution and a statute, a misunderstanding between framers and parliamentarians. Number four, this is the funniest one that I read. When I read, I said, oh my God, how can this even be in a Supreme Court opinion? It says, if the plaintiff did not complain when some act was passed in 1993, why is he complaining now? It's actually in there, in the report. Number five, Parliament must be free to adapt. Maybe there's COVID, and they should be able to set the Constitution aside and do whatever they want. Number six, Parliament has implied power. I don't even know what that means.
Residual power. Residual power. It's there in the Constitution.
Agency law that has no relevance whatsoever to what we are talking about. Number six, Parliament used its residual power. Now, the Hansard itself says that Parliament used its power under Article 191D. And the court is saying something else, that Parliament used its residual power under Article 298. How can Parliament use a residual power on a matter that the Constitution has a voice on? The Constitution has prescribed something. So residual power does not come in at all. It is plain error. It is just so wrong to be talking about residual power in a matter like this. Number seven, the special prosecutor position is analogous to some other offices. And so if the Constitution has allowed those other offices to be retiring at 70, then Parliament too can allow the special prosecutor to retire whenever they want. Number seven, the Constitution must not be interpreted narrowly. It must be interpreted purposively. But they didn't interpret the Constitution purposively. The whole purpose of having a constitutional retirement age is to take the question from Parliament. We don't want parliamentarians and politicians to be messing with the retirement age. That is why it has been constitutionalized. Otherwise, we would leave it to them to do it. But we know our history. starting from the Nkrumah regime, where the public service was supposed to be Africanized, and then later on it was politicized, almost always because the politicians are seeking public servants who are loyal to them. And so with that in mind, the framers decided when it comes to retirement, except where the Constitution itself has made an exception, the retirement age for anyone who is in the public service is 60, case closed. So in this case, you have to ask two questions. Is the office of the Special Prosecutor part of the public service? The court itself says yes. Parliament says yes. So that's not in dispute. That resolves the question. Once the office is part of the public service, the retirement age for them is 60. Now, the court looks at all kinds of ages in the Constitution, and it doesn't give a framework, or it doesn't seem to be understanding what the constitutional drafters are doing. When you actually look at the Constitution, it's very smart. What it has done, there are two types of people in the Constitution in terms of retirement age. What I call elected officers or at-will officers, and then for cause. For cause means you cannot dismiss these people without a very good reason. The at-will or elected officers typically have no retirement age. The Constitution doesn't talk about the retirement age. So if you want to run for president and you are 100 years old, you go do it. The voters will decide, and if they are not happy with you, then they'll fire you. So there's no need for us to put a retirement age on that. Then we also have political appointees. Political appointees, they serve for a term. The voters don't like the person who appointed them. That's it, they are gone. Then there is another group called the public corporations. But the public corporations who are set up as commercial ventures. So we want those, even though they are state-owned enterprises, we want them to be run like commercial enterprises. So to be competitive with the public, private sector, let us not impose any age requirements on them. So the court asks, why is it that BUI Power Authority doesn't have a retirement age? Well, the Constitution answers that. They don't have a retirement age because it's a public corporation that is set up as a commercial venture. So you put that aside, then is the for cause. The for cause, I put people in three buckets. Either you are a Supreme Court justice, or you are a Court of Appeal justice, or you work for SHRAJ, or you are a member of the Public Service Commission. In those scenarios, the Constitution itself says, okay, these guys, they'll retire at 70. Then there's another bucket, the High Court, the Deputy SHRAJ people, the Deputy Public Service Commissioners, they retire at 65. So those are the only exceptions. Everybody else will retire at 60. That is why the Auditor General in the Audit Service Act retires at 60. And that's why in the Apia Ofori case, the court said, look, the Auditor General, even though he's an Article 70 appointee, his retirement age is not specifically in the Constitution, and therefore he must retire at 60.
Okay.
This is to me a very, 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 very simple constitutional question.
Hold on there for me, and let me bring in Godfred Dame, who also prosecuted this matter and has graciously agreed to assist us in understanding the decision. Godfred, thank you very much for making time to join us.
Right, Samson, thank you very much.
What do you say about the difficulty that people like Professor Kweku Asare have in understanding what the Supreme Court's majority or the decision went through to come to the conclusion that the position of Dominic Ayine was wrong? They took us through a number of public officers and indicated that even though these public office holders are public service persons, they have different retirement ages. So for Dominic Ayine to insist that once the office was created as a public service, the retirement age must be 60. Why,
Right. Okay.
why do you think people can't seem to understand that
Right.
this is good, law from the Supreme Court?
Well, fine. Well, let me just wish warm regards to my good friend Dr. Ayine and Honorable Penka, and of course Professor Asari, who I happen to be counsel for in the challenge of the Constitutional Review Commission's work in
Great.
2015. So I know them very well, and I like all of them. But the point is that, and it must be placed on record, that the Supreme Court did not go through any difficulty whatsoever in rationalizing the conclusion it did. Indeed, the numerous examples it stated was actually an attempt to indicate clearly that they don't state anything new. And as far as I'm concerned, the ruling only affirmed and endorsed the position prevailing at law in Ghana. That is why the court had to go through great extent to show examples of various statutes since 1992. Now something, in the laws of Ghana, there is standing on the statute books a law known as the Laws of Ghana Revised Edition Act. It was passed in 1998 at 562. That law provided in Section 1, subsection 1 thereof, for the appointment of a statute law revision commissioner by the President, Constitution, the Council of State, and Minister for Justice. That law did not provide for any tenure at all. On that basis, the Attorney General then, Dr. Obedasamu, appointed Vincent Cyril Richard Arthur Charles Crabb, a gentleman we all know as VCRC Crabb, to that office. VCRC Crabb's appointment was renewed by his successor, Nanadan Kwekufadu, who has been the president now. Successive Attorney General and Ministers for Justice, including Joe Gatti and Betty Molidusu, continued VCRC Crabb's appointment. At the time VCRC Crabb was appointed, it was well over 70 years. And he continued in office until it was well over 90 years before retiring from that office and eventually dying at the age of 94. So clearly, it tells you that if indeed Dr. Ayine, with all respect, would want to look at the law impassionately, I mean, and clearly, objectively, who come to the conclusion that it is not uncommon, neither is it illegal, to appoint a public officer, and the emphasis is on public officer, who is over the age of 60 years. And that has actually been the source of, with all respect, the confusion that was manifest in the kind of submissions that were filed in court. And my view is that indeed, if the submission by the plaintiff in that case, the Ayine and Attorney General, were to be appealed, clearly it would have amounted to an endorsement of a position totally alien to the Constitution of Ghana, and which, if appealed, would have disrupted the efficient running of public administration in Ghana. Because really the case was founded on the constitutional fallacy. It was a complete fallacy and a false premise to proceed to say that the Constitution prescribes a retiring age for all public officers. No, there's not at all.
Okay, so make note of that.
Characterize that position.
Make note of that. No, make note of that.
We told you, explicitly. I mean, I cannot allow him.
No, make note of that. You are here. You have the opportunity. You have the opportunity to respond. Please make note of that. Thank you.
If Dr. Ayine says that what I'm saying is false, may I quote from paragraph 7 of the amendment of case filed by Ton Lisa in court. It says, by reason of his age, second defendant, at that time, second defendant was Martin Amidu, who was subsequently struck out. Second defendant is not qualified under Act 9592, but the Attorney General appointed by the President of the Republic and approved by Parliament for the position of Special Prosecutor. This is because by his appointment, he would become a public officer within the definition of Article 295, and under Article 109 plus 1 of the 19th Constitution is older than the constitutionally prescribed retirement age of all public officers, which is 60 years. Yes. But that is wrong. There's no such thing as a compulsory retiring age of all public officers.
No.
That's the point. Now, that's what I'm saying, that the case was built on a constitutional fallacy, and it must be demonstrated clearly. Now, you see, the Constitution again, with all respect, does not also prescribe for how public offices in general must be created. The Constitution rather provides in Chapter 14 for how the public services, and the emphasis on services, of Ghana will be set up. and then direct that Parliament may by law prescribe for the service of the public services, and also indicates in Article 195, Clause 1, how an appointment to an office in the public service should be done. So you see, if how would you view that? Indeed, the reason why the Constitution does not prescribe for how public offices generally can be created in Ghana can be found in Article 295. The definition of public office clearly is distinct and must be distinguished from that of public service. And the Constitution says so. Public service, in its narrow definition in Article 295, has many broad elements and very defining characteristics. Beyond the simple fact of drawing a monument from public funds, there is also a requirement in Article 195 for the person to be appointed by the President in accordance with the advice of the Governing Council of the service concerned. And that advice must have been given in consultation with the Public Service Commission. Article 295 indeed says that public services includes service in any civil office of government. And government, of course, has been defined in Article 295 to mean any authority by which the executive authority of Ghana is duly exercised. But public office, however, is broad and all-encompassing. If you look at Article 295, it says that the only factor is that the person should have been drawing a monument from public funds. It implies that the President, the Vice President, the Speaker, members of Parliament, the Commissioner on Human Rights, and various chief executive officers of state-owned enterprises and board members of a number of public corporations are all public officers. However, in Ghana, there is no such thing as a retiring age for public officers in general. The point we made clearly is that indeed, by Act 959, that's the Public Office of Special Prosecutors Act, Parliament had carefully stepped up an office and specified conditions regarding the holding of the Office of Special Prosecutor as well as the Deputy Special Prosecutor. And then Parliament, again, in the same act, specified a different manner of appointment for other staff of the Office of Special Prosecutor. So you see that Section 13.1 says, Section 13.3, it says the Attorney General shall nominate a person qualified for appointment as Special Prosecutor by the President, subject to approval of the majority of all members of Parliament. The same provision holds in Section 16.2 for the appointment of the Deputy Special Prosecutor. But then, when it comes to other staff, it is indicated clearly, appointment of other staff, that they shall be appointed in accordance with Article 195 of the Constitution. So you see that there was a deliberate effort. It's in Section 21, appointment of other staff. The President shall, in accordance with Article 195 of the Constitution, appoint other staff of the office that are necessary for the proper and efficient performance of the functions of the office. So clearly, you saw that deliberate distinction drawn. And I'm saying that's what made the point that indeed, where is the prohibition in the Constitution that Parliament cannot create a public office and then within the specific confines of the statute that has been passed, specify a particular requirement or a particular manner of appointment for the leader of the office, as well as also specifying different tenure of office for the other staff. It's all there. So we must clearly have the understanding that the Constitution defines public office and public service differently.
Okay.
And when account is taken of this, you will then come to the irresistible conclusion without any difficulty at all that the plaintiff's case in the Amidu matter was very simplistic and founded the constitutional fallacy.
Right. So hold on.
I'm saying that indeed, this is not the first time that Parliament of Ghana had enacted an act of Parliament specifying such arrangements. That is why I alluded first to the Laws of Ghana Revised Edition Act 1998 at 562, under which Justice B.C. R.A.C. Cap was appointed when he was over 20 years, to hold office for over 20 years until he died at the age of 94. Then also we can make reference to the District Assembly's Common Fund, which you have earlier on alluded to.
Right.
The Labour Act 2003 at 651. If you look at Section 143, it talks about tenure of office of members of the Commission.
Right.
So the members of the Commission shall hold office for a period of 4 years and are eligible for reappointment. Is this unconstitutional? Indeed, going by any argument, then it will imply that if I am appointed a member of the Labour Commission, when I'm 1 year...
Now just hold on briefly. Hold on briefly there. Now, Dominic, the question is, did you not put up a petition that from what the court has canvassed is not supported by the law. The position that once the OSP Act creates Martin Amidu's office as a public service and adds to the list of public services in the Constitution, his retirement must be 60 years, and therefore he's unqualified, and they should say so.
Yeah.
The Supreme Court, like Dami has also referred to a bit of it, they took time and took you through a number of retirement ages. They made distinction between political public office holders and the not the bureaucratic, service holders who are serving. They spoke about judges. Judges are part of the list of
something you can ask.
Are part of the list of the public service.
I will deal with them.
Several institutions are part of the public service,
yes.
But the persons in these offices do not retire at 60. Court of Appeal judges don't retire at 60. Supreme Court judges don't retire at 60. High Court judges retire at what? Is it 65?
65, yeah.
65.
Yes.
Then they give you all the others.
Something. I think you are taking too much time. We are all lawyers. Yes. We have read the judgment.
So yes.
I think what happened, and this is why I interjected when my learned friend, the Deputy Attorney General was speaking. The point is this: the section of our pleadings that he referred to did not say that we were asserting that there is one uniform retirement age for all public office holders.
The judgment said that's what your position was.
He mischaracterized that position in his response, in his legal arguments, and we said that was not the issue we're bringing before the court. And that is why Justice Doji pointed out that we had said explicitly that wasn't the issue. We had never said that there was one retirement age for all public office holders. And in fact, Samson, I would encourage you to go, if I can send you the legal arguments filed by Tony Lita. In fact, Tony Lita took his time.
I have both of them.
Yes, but you saw in our legal arguments that we pointed out quite clearly that there were different retirement ages for different public office holders. This is an argument that we made, and it is very disingenuous on the part of the Deputy Attorney General, and then on the part of the court to say that we sought to, say that there was one uniform retirement age for all public office holders. Our case was very simple. It was that the OSP, the Office of the Special Prosecutor, is an Article 191D office, and there was plentiful evidence to that effect. Being an Article 191D office,
that's a public service.
It is part of the public services of Ghana, strictly and properly so called. He is just not an ordinary public officer. He is not a political appointee, a minister. He is not a judge. He is not a, what do you call it? A chairman, yes, an independent constitutional body and so on. But he is one appointed pursuant to Article 191D of the Constitution, which is located in Chapter 14. So his office is part of the public services of Ghana. And our argument was that, the officer is a product of the office. You must first create the office by law before the office holder can be appointed to occupy it. So being a product of that office, he was governed by the rules of retirement that govern that particular office. And that is under Article 199 of the Constitution. Now, what he put before the court was that we had said that there was one retirement age for all public office holders. That is not true. There is no evidence at all in our pleadings that is what we said. Secondly, the distinction that he sought to draw between public officers and public services, what do you call it, as I said it some time ago, an exercise in sophistry, because that wasn't what we were, putting before the court, He set up a straw man. The Supreme Court adopted his straw man, knocked it down, and said that they've won the case. The reason why we said Martin Amidu was appointed pursuant to a public service office created under Article 191D of the Constitution is very simple. The Attorney General herself, his boss, when she came to Parliament, acknowledged that this was an Article 1901D office. All right? The chairman of the Constitutional, Legal, and Parliamentary Affairs, in justifying why we were creating a board, said this was an Article 191D office. And we made the hands up. Yeah, no, I'm coming.
That's not in doubt.
No, I'm coming. No, please. Your colleague has taken a lot of time. Let me. Pemka. No, please. Let me finish and then you can respond. All right. Now, something, come to think of it. Let's say, for the sake of argument, that even this evidence we placed before the court was not available. All right. What services is the Office of Special Prosecutor going to provide? They are providing legal services. Prosecutorial service is legal service, and the legal service is part of the public services of Ghana. Look at Article 190 of the Constitution. I think you have it here.
No, but
right?
my question to you very briefly is this. You say it's an office created under 191.
Yes.
191 is the public services of Ghana.
Look at 191D.
I'm coming. 191 says the civil services of this country, the public services of this country shall include the civil service, the judicial service. Now, the judges, they don't all go on retirement at 60.
You see, that is where you
they use that example.
No,
Did
please,
they not?
Please. The judicial service is different, when it comes to the appointment of judges, and the Constitution itself makes that very clear.
Okay.
All right. Let's take the judicial secretary. The judicial secretary, or any person working as a registrar, is governed by Article 90 of the Constitution.
Okay.
So they retire at the age of 60. Now let's even look at this. The DPP, the Director of Public Prosecutions, right? Appointed under the legal services, retires at 60. So why is the DPP different from Martin Amidu? Do you get what I'm saying?
Okay.
And the whole idea that the Supreme Court said he was analogous to an Article 70 appointee is one of, as Asari said, one of the funniest reasons to have been given. The reason is simply because Article 70 vests the President of the Republic with power to appoint certain listed officers. And then in 71E, it then says that, and such other offices, created under this Constitution or by an act prescribed by Parliament. All right. Now, Parliament is not being given power to create an office under 70. Parliament is given power to create the offices specifically mandated under the Constitution. In the case of the Public Services of Ghana, 191D, and then in the case of the DACF, that is the Common Fund Administrator, look at Article 252, Clause 5 of the Constitution. It says that Parliament shall determine not only the terms and conditions of office of the administrator, but also the tenure of office. So the Constitution even provides that Parliament can enact law to determine those ones.
Okay.
All right. So wherein lies the exercise of residual power?
I see.
When you see that the Constitution has provided for it. So all the examples that they cited, all right, if you come to Bank of Ghana, look at the chapter look at Article 183 of the Constitution. All right. When it comes to EOCO, that is where I even saw that the court did itself a lot of disservice, because the EOCO was enacted pursuant to Article 190 of the Constitution. Go back to the history, go back to the Hansa, and that is why the executive director of the EOCO, all right, retires at 60.
Okay, hold on, Godfrey. Yes.
I think that certain words, with all respect, have been used here in the court in the description of what the Supreme Court did. And for instance, Dr. Aini just said that one of the funniest reasons. I think that such language, with all respect, ought to be deplored.
No, but the judgment is out there. The judgment is out there. It's subject to criticism.
No, please.
This is not a matter that's still pending before them.
You are not the one to teach me what to say about judgment.
We can say that a decision is absurd. Is unreasonable.
Well, that is even an absurd decision.
Listening to Dr. Professor Asari, he made reference to Justice Doji's judgment and described in very glowing terms. As far as I'm concerned, very material parts of Justice Doji's judgment actually supported the case for the defendants. Indeed, if you look at page 69 of Justice Doji herself.
She dissented and said the majority decision was wrong. Why do you say she supports them?
I'm saying that even the reasoning, with all respect, the reasoning of Justice Doji actually, if you look at it, was manifestly supportive of the case of the defendants. And it shows some contradictions. It says that there's no doubt or controversy as far as about definitions are concerned that public office embraces a wider scope of public officers, including public officers in the public service. Article 190 specifically provides in clear terms institutions that are classified as the public service of Ghana. Clause 4 of Article 199.4 describes public office holders in the public service created under Chapter 14 of the Constitution.
Okay.
So this actually shows that when, as I submitted in court, that indeed when we say public officers under Chapter 14, it must be construed as a term of fact. That's exactly what it is.
Okay.
It's actually referring to public officers appointed within the context of Chapter 14,
right.
and not all public officers generally.
Okay. Gentlemen, I'm sorry, but once again, I don't know where the time went. I'm sorry, but our time is up. It has been a very revealing and interesting discussion, but this judgment obviously is a judgment that will be subjected to further discussion going forward. But your colleague is on the line. Sorry, my guests have been
because you were two and I was.
My guests have been Dr. Dominic.
I needed to draw your attention to something. And
my guests have been
allowed me to draw the attention.
Dr. Dominic Akuntinga Ayina, and my people will punish me for having said that wrong. I'm being rushed from all angles. He's the MP Boga East and chairman, Subsidiary Legal Legislation Committee of Parliament. Joseph Dindiok Penka is MP Timpani and Deputy Attorney General and Minister for Justice. And somebody very interestingly says the three of us from the same place are sitting on the show. It doesn't change anything. Also, Professor Stephen Kwekua Sari, fellow CDD Ghana and D&D fellow for Public Law and Justice. Godfred Yeboah Dame, Deputy Attorney General and Minister of Justice, has just left us on the phone. Don't go anywhere today. Keep your channels and your dials on Joy, because you have the Beyond the Lockdown COVID-19 impact on sports. That's tomorrow, Sunday, at 7 p.m. You can enjoy that. Also, coming up is the Joy Sports Link. Right now, Nathaniel Arthur will be interviewing Stephen Appiah. Thank you. My name is Samson Ladia Yenini. And as always, my outfit, it's by Latida. Thank you all.